ma'am, you got to figure out having Mr. Walker contact Mr. Grable. He shouldn't even be doing it through text, quite frankly, unless it's an emergency. He shouldn't even be doing it. And that stuff that he sent was completely inappropriate. Ma'am, you got to matter of Grable versus Grable. 22-7436-DM's motion filed by the father, in this case to exclude a third party, Mr. Walker, from being around his kids. It's a lot of things that he's had criminal background and counsel. I'm going to tell you right now, even before I got the response, I mean, there's nothing of substance past about 2009 other than a driving offense. And I mean, the fact that he back in 2008 or something had some drug offenses is not, doesn't impress me at all. So you can go ahead, and if you want to add anything, counsel, you may do so on behalf of the defendant.
I understand, Your Honor, and I will focus then the information that I provide to the court on what we don't know and what plaintiff's response has failed to provide to the court. But first, my client wants to impress upon the court that his motion was filed strictly to protect the party's 3 very young children from potential harm and for no other reason. Plaintiff's assertion that because he waited after he first had concerns, there is somehow no risk to the children or merit to his pleading is not an argument at all. It's a deflection. My client waited because he was assured by plaintiff that she ended the relationship, and he filed after plaintiff and Mr. Walker later went Facebook official with their reconciliation in mid-July of this year. I'll simply state what we don't know about Mr. Walker and what's missing from that response, as I mentioned. We don't know if Mr. Walker has maintained his sobriety, and probably the most significant.
You never will, and you don't have necessary. This is her new boyfriend or whatever. Okay, you don't get to drug test him, or I mean, how's he supposed to show he is or isn't? I mean, it's up to the mother to make sure that the children are protected. And if he's drunk and causing a problem, and I don't have any of that in the pleadings anywhere.
I understand, Your Honor, but part of the problem here is that Mr. Walker's parenting time in Ottawa County is supervised with his own child because he's failed to verify even what they've specifically asked for of him. And if he has to be supervised with his own child, he shouldn't be left alone with Mr. Grable.
All right. What else do you have?
We don't know if the evaluation that was alluded to in plaintiff's response as completed last month has actually been completed, or that despite plaintiff's many exhibits, it's clear there's no exhibit verifying he ever submitted to one, and no licensed professional is even named by plaintiff in her response, and nothing has been provided by his treating psychiatrist to indicate those things that Ottawa County has been asking for approximately 3 years. And finally, we also don't know, as there is no sworn signed statement provided by plaintiff, that Mr. Walker has actually exercised unsupervised parenting time with his own child, despite a text exhibit that suggests he might have. He's been asked to provide proofs related to all of that in his own case and hasn't. Here, plaintiff has provided zero proof on his behalf too, likely because he hasn't or can't provide it to her, which appears to be his pattern. That's all I have, Your Honor.
Okay, well, all right, counsel, Ms. Johnson.
Just very briefly, defendant bears the burden here. So pointing at all the things that they don't know, that's not a shortcoming on plaintiff. They've not highlighted a single instance in which Mr. Walker has allegedly put these children in harm. It's all of this, it could potentially happen. And as you referenced, it would be mother's responsibility to step in and prevent that. Mr. Walker is not a threat to these kids. These kids have known him and come to love him over the course of the last year. It is false that defendant did not know that they were together. We have text messages from March. We have text messages from November. We have text messages from July.
We have some inappropriate text messages also. I mean, go ahead. I mean,
I don't think plaintiff has met, well, the defendant has not met his burden to exclude this individual from the children's lives. There's no evidence of harm. So to state that it is the plaintiff's burden to prove a negative, they haven't provided anything that would indicate that there's a current threat.
All right, thank you. Well, first and foremost, obviously, Ms. Grable has moved on as another person, and I'm not gonna micromanage that relationship. These parties are divorced. They're both gonna go their own ways, and I'm not gonna sit here and try and figure out if the other's significant other. I'm just not gonna do it. If you can point to me some harm that the kids have suffered as a result of him, certainly, and not only would I prevent it from continuing, but Ms. Grable would have to answer for it, probably in a motion to change parenting time or custody or something like that. I mean, she's the one responsible to make sure the kids are safe. And if there becomes domestic violence and the police are called and this kind of stuff, that's stuff that goes into possible change of circumstance, proper cause to look at change of custody, certainly change of parenting time, certainly it would at that point rise to the level of maybe he should be excluded from that. But I don't have anything other than a lot of, gee, you know, I started out telling you, a lot of this starts out saying, you know, he's got an extensive criminal history, and I look at it and I see, holy smokes, he's got one driving offense in the last 15 years. Other than that, he does have history before then, but it certainly has not reoccurred. I did read through the, I think it was referee Magley. It wasn't a very complimentary thing towards Mr. Walker and his children, but I don't think it provides enough to require that he not have contact with the children or supervised at all times and things like that. I don't know what's going on, and I don't really know a lot of the underlying. I do see Mr. Walker, I don't care how you want to paint it, as being a knight in shining armor or whatever. Ma'am, you got to figure out having Mr. Walker contact Mr. Grable. He shouldn't even be doing it through text, quite frankly, unless it's an emergency. He shouldn't even be doing it. And that stuff that he sent was completely inappropriate. However, I don't even know why Mr. Grable is sending back even emojis or something to respond to it. I don't even know why you're even responding to this guy. You guys have got to figure this stuff out. I'm going to deny the motion at this point. You know what has to be done. So I'm not going to exclude him from being around the children, and but Miss Grable better make sure it's always appropriate. It's her that's on the hook, not Mr. Walker. Good luck, everybody. You can draft the order, Miss Johnson.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, Your Honor.
Thank you.